When I first saw this video, I immediately classified the officer's actions as legally justified, but likely unnecessary. I watched the full body camera footage of this stop. I reviewed the state attorney's office investigative report. I reviewed the use of force policy for the Jacksonville Sheriff's Office and the Orange County Sheriff's Office and compared those policies to the officer's actions. I've worked with the Jacksonville Sheriff's Office on more than one occasion. These officers are highly trained, highly motivated, and aggressive. There's a lot that responsible citizens can learn from watching this video. Let's dive in. The driver was pulled over for two different violations of law: not wearing a seatbelt and not using his headlights in the rain.
Two things: you're not wearing your seatbelt.
It's green light. I don't need the lights. It is not raining. It's not raining.
It's not raining. Okay, I'm not arguing with you. I'm telling you why I'm pulling you over. Give me your driver's license, registration, proof of insurance.
No, call your supervisor. Why?
Excuse me?
Call your supervisor. Why did you pull me over?
I've already told you.
Why did you pull me over?
Step out of the vehicle.
No,
Step out of the vehicle.
The driver was refuting the legality of the stop and requesting a supervisor. And I understand why. He was being criminally profiled by the officer and stopped for a BS pretextual violation. Let's define that. A pretextual traffic stop is the situation in which an officer conducts a traffic stop for the stated purpose of a minor violation, but really for the unstated purpose of investigating other criminal activity. How does that apply here? The driver was seen leaving this house. It has been flagged by the Jacksonville Sheriff's Office as having ongoing illegal drug activity. That's why the deputy pulled him over. That's a high percentage stop. The driver knows the officer's response about the reasons for the stop is not the complete answer. This only serves to escalate the stress levels. The driver's license is suspended, he's got weed in his pocket, and there's a huge hunting knife right at his feet. He knows he was targeted, he feels like he was wronged, and he's coming to grips with the idea of going to jail. Everybody kind of knows that stress can cause some unusual behaviors. Police officers understand this well. Good police officers use the psychological power of stress and other psychological phenomenon to gain a strategic advantage in their investigations and in their encounters. Let's go back to the stop. The deputy tried to explain the reasons for the stop, but the driver didn't want to hear that. He demanded a supervisor respond to the scene. He shut the door and locked it. The deputy got on the radio and requested backup units, including notification of a supervisor, and provided everyone listening to the channel an update as to what was going on. The deputy instructed the first responding backup unit to tactically park the vehicle. Let's define that. Tactical parking is the blocking of a vehicle so as to prevent escape. In a dynamically unfolding situation, the officer doing the tactical park is expected to collide with the vehicle that's being parked.
Okay. Right now you're under arrest for resisting. You understand? You're under arrest for resisting. The longer you take us on, the worse it's going to be. Keep your hands where I can see them, sir. Okay. Sir, it's your last warning to open the vehicle and exit before we're going to break the window.
These tactics are 100% justified in this style of police interaction. Throughout this encounter, the deputy was interacting with the driver. He was warning him of repercussions, ordering him to get out of the vehicle, and he eventually placed him under arrest verbally through the window. Once the first couple backup officers arrived and the vehicle was tactfully parked, there was no need to delay.
I'm trying to break the window. Exit the vehicle now! Exit the vehicle! Show me your hands. Here.
The officer gave him a few final warnings, broke out the window, yanked open the door, palm struck the face, extracted him from the vehicle, dog pile lead to cuffing. After his arrest, the driver pled guilty to resisting without violence and then released the video footage on his own and created a GoFundMe page. To evaluate this case, we have to review the police's use of authority at each stage of the investigation. We'll start with the stop. In Wren, the United States Supreme Court ruled the officer's subjective intent is irrelevant so long as there's an objectively valid reason for the stop. Headlights off during the rain, not wearing your seatbelt, both of those qualify as legal grounds for the stop. So we move on to our next use of police authority, the order to exit the vehicle. Like it or not, the United States Supreme Court has ruled that the police officers can order the occupants of a vehicle to exit or stay in the vehicle at their discretion. That means that the order to exit the vehicle can, and in this case was, converted into a lawful order. If a lawful command is given and it's violated, that's resisting an officer without violence, and the person is subject to arrest. When someone is subject to arrest, we open up statute 776.05 and 776.051. An officer need not retreat or desist from making a lawful arrest because of resistance. I believe this statute gives the officer the legal authority to break out the window. It helps that the military and law enforcement communities recognizing break and rake as a viable option for extracting someone from a vehicle who's uncooperative. Upon breaking the window, the officer enters his hand into the vehicle to open the door. By doing so, he has crossed the threshold into a place where a person has a reasonable expectation of privacy. By textbook definition in the police academy, this is a search. The Fourth Amendment protects us against unreasonable searches and seizures by government actors. I don't think the Fourth Amendment applies in this scenario because I don't think this search is unreasonable and therefore doesn't meet the threshold. He locked himself into a car in front of the officer to evade arrest. If we allowed that to happen overall, the result would be insane. It's not unreasonable. In order to analyze the open hand palm strike to the face, I had to look at the Jacksonville Sheriff's Office use of force policy. I have to say, it's not well crafted. It appears to attempt to blur the lines for protection in lawsuits at the expense of clarity and understanding. My initial assessment of the palm strike to the face was a level 2 distractor. I texted that to my attorney group chat. Later, while researching this project, I discovered the Jacksonville Sheriff's Office and the State Attorney's Office use that same language. A distraction technique is where the officer delivers a quick targeted strike to create a brief distraction, allowing the officer to gain control of a subject or create an opportunity for another action, like taking a subject into custody. If we review the Orange County Sheriff's Office policy, we won't find the word distraction technique because they use the term touch. Let's look at that term. A deputy may use a soft assisting touch when guiding, directing, or obtaining the attention of a subject, or a firm, strong touch prior to escalating to a higher level of force. Looking deeper into the policy, you'll see that a level 2 touch does not require the notification of a supervisor, and there's no formal use of force reporting. No reporting? Why isn't everyone getting bitch smacked? In my assessment, the highest level of force the officer has used thus far is level 2. In order to determine whether that force was justified, we need to assess the driver's behavior and rank that on the appropriate scale. To do this, we look to the left side of the use of force matrix, starting from the top down: aggravated physical, aggressive physical, active physical, passive physical, verbal, and presence. Each one of these has its own definition. I believe that passive physical resistance is the most applicable, but you can make up your own mind. That puts the driver at level 3 and the officer's distractor response at level 2. That's justified. But even if you classify the open hand distractor as an open hand palm strike, it's still a level 3 event and legally justified. To determine whether this is a level 2 distractor or a level 3 palm heel strike, we need to use the acronym TITS. What was the target? What was the intensity? How long did it last? Or how many times? This contact is clearly a distractor. It's also known that distraction techniques are used in resolving high-risk incidents. We look to the acronym of SAS: speed, aggression, and surprise. The officer used all 3 of these effectively to bring this to a quick resolution. This second punch is clearly not a level 2 distractor. It's an uppercut with moderate degree of intensity. That's level 3 all day long. But before we can determine whether it's justified or not, we have to evaluate the driver's actions according to the same scale. If you look back, you'll see the difference between passive physical resistance and active physical resistance is the bracing and tensing of muscles. I certainly think that he is bracing and tensing muscles in this scenario, which means that he's at active physical resistance level 4, authorize the officers to go up a scale, but they're still at level 3. I'm assuming that most of you have never done this type of analysis before. What do you think? I'm also curious if you've ever given thought to the type of analysis that will be applied to your use of force scenario should you have to shoot someone. In this video here, I've created a breakdown of Florida's anti-riot stand your ground laws that protects you against rioters or protesters. Thanks for watching. Hit it hard.